Understanding pleadings. 1. What are pleadings in the context of a lawsuit? A. Oral arguments presented in court. B. Documents filed in court or included in a trial record. C. Witness testimonies recorded during trial. D. Settlement agreements made before trial. Answer: B. Documents filed in court or included in a trial record. 2. Which of the following is not considered a pleading? A. Statement of claim. B. Interrogatories. C. Witness testimony. D. Statement of defense. The correct answer is C. Witness testimony. Explanation. Pleadings are the formal written documents exchanged between parties in a lawsuit that set out their claims and defenses. Examples include statement of claim, filed by the plaintiff to start the lawsuit. Statement of defense, filed by the defendant in response to the claim. Counterclaim or reply, if applicable. Interrogatories are not pleadings, but they are part of the discovery process, written questions one party sends to another to get facts before trial. Witness testimony is evidence presented at trial, not a pleading. That's why C. Witness testimony is not considered a pleading. Witness testimony is not considered a pleading because it is evidence, not a formal written statement used to start or respond to a lawsuit. Why option C. Witness testimony is not considered a pleading. Pleadings are written documents filed by the parties, like the statement of claim or defense, that explain what each side is arguing, what they say happened, and what they want the court to decide. Witness testimony, on the other hand, happens later in the trial when witnesses speak under oath to tell the court what they saw, heard, or know about the case. It helps the judge or jury find the facts, but it does not outline legal claims or defenses. In short, pleadings equals written statements of legal positions. Witness testimony equals spoken evidence given during the trial. 3. What is the primary purpose of pleadings in a trial? A. To serve as the final decision of the court. B. To provide the judge with a basic understanding of the dispute. C. To replace the need for a trial. D. To be used solely for out-of-court settlements. Answer: B. To provide the judge with a basic understanding of the dispute. 4. When does the court review the pleadings in a lawsuit? A. Only after the trial begins. B. After witness testimony is presented. C. Before the commencement of trial. D. After the final judgment is issued. Answer: C. Before the commencement of trial. The court review the pleadings in a lawsuit before the commencement of trial. Witness testimony happens later in the trial when witnesses speak under oath to tell the court what they saw, heard, or know about the case. It helps the judge or jury find the facts, but it does not outline legal claims or defenses. Commencing litigation. 5. What document does the plaintiff draft to begin the litigation process? A. Statement of defense. B. Statement of claim. C. Witness affidavit. D. Motion to dismiss. Answer: B. Statement of claim. 6. In some provinces, the statement of claim is accompanied by which additional document? A. A demand for particulars. B. A writ. D. A counterclaim. Answer: B. A writ. Explanation. The correct answer is B. A writ. Explanation. In some provinces, for example, in certain parts of Canada that follow older common law procedures, a statement of claim is accompanied by a writ. A writ is a formal legal document issued by the court that officially begins the lawsuit and commands the defendant to respond to the plaintiff's claim. The statement of claim explains the details of the plaintiff's allegations, while the writ gives official notice of the legal action. Why the other options are incorrect? A. A demand for particulars. This is a request made after a pleading is filed if more detail is needed. It does not accompany the statement of claim. D. A counterclaim. This is also filed by the defendant, not the plaintiff. and it happens after receiving the statement of claim. Therefore, the correct answer is B, a writ. 7. What is the equivalent of a statement of claim in British Columbia? A. Writ of summons. B. Notice of civil claim. C. Statement of defense. D. Motion for summary judgment. Answer: B. Notice of civil claim. 8. What is the statement of claim called in the United States? A. Complaint. B. Motion. C. Counterclaim. D. Affidavit. Answer: A. Complaint. 9. What key elements does a statement of claim include? A. Only the names of the parties involved. B. The parties, allegations forming the basis of the claim, and relief sought. C. A summary of witness testimony. D. The final ruling of the court. Answer: B. The parties, allegations forming the basis of the claim, and relief sought.